Okay, so the concept of auto fraud is based on the practices that dealers use to get cars off their lots without telling the customer what they're really buying. So the big three violations that we look for are if the car has been involved in an accident, if the dealer is rolling back the odometer, or if the dealer sells the car above what they've advertised it for. So those are the three big common auto fraud violations. Usually our clients find out that they have been frauded or defrauded when they take their car to a third party. For example, let's say you buy a car and it's you and your spouse, and you drive the car for 2 years, and then surprise, you're gonna have a baby, and you realize that car is too small, so you take that car to a different dealership to trade it in for a bigger car. And then at that time, the new dealer will run a report, either a Carfax or an auto check, and then they tell you, Mr. Smith, we can't buy your car back for full price because it's been in an accident. Well, Mr. Smith knows that it wasn't in an accident during his ownership of the car, so at that time he finds out that the vehicle was in an accident before it was even sold to him. That's the primary way people find out, is when another party, either a dealership or sometimes even a mechanic. So let's say they get into a car accident or their car breaks down, and then they take it to a mechanic. And if they were hit, let's say they were rear-ended, and they take their car to a body shop and they tell the body shop guy, I was in an accident, can you please fix my car? Well, when the body shop mechanic does an inspection of the entire vehicle, he might find damage in parts of the vehicle that was not damaged during your accident. And then the body shop guy will say, hey, you were hit from behind, but did you know there's damage to the front bumper or the passenger door? And then that's another way people find out. And the advertised price is kind of tricky because the financing of vehicles can get kind of complicated. There's so many pieces of paper and so much information involved in the car buying transaction that people usually don't know that they're being sold the vehicle above the advertised price. Sometimes what happens is the client will come home. They bought the car, they're happy, they come home and they'll start looking through the paperwork, and sometimes what prompted them to go and buy the car is an ad. They see it on the dealer's website, or they see it on Car Gurus or Auto Trader, and then they realize that, let's say the car was advertised for $21,995, but then when they look on their contract, it was really sold to them for $24,995, and that's a violation. So those are the three big auto fraud violations that we see. First thing is, you should call an auto fraud attorney. We offer free consultation, and this practice area is very document intensive. So if you have the paperwork to show that the dealer committed these violations or committed fraud, it strengthens the legal legs of your case, and there's a higher probability we can help you. So if you call a law firm, they'll do a brief intake and get some basic information, such as when you bought the car, how you found the car, the name of the dealership, who your finance company is, and then you'll explain to them why you're calling. Is it a disclosure issue? Is it an odometer issue? Is it an advertised price issue? And then once we've done the consultation, we need to see your documents. So we ask that you send them in via fax, email, smartphone, traditional US mail, in any means that you can get the paperwork to us. We do a review. It takes us about 24 hours, and then if the paperwork is able to support the violations that you're complaining of or the allegations that we feel are pertinent to your case, at that time we believe that you have a case strong enough for us to take. Okay, so let's say you found out that your car was in an accident, but the dealer never told you. We would either need a Carfax or an auto check or a visual inspection conducted by a body shop, and they will prepare an estimate or an invoice for the repairs. Those are the three big evidence pieces that we like to look for. If it's an odometer fraud issue, it's pretty similar. Carfax and auto check, and actually also the NVIDIS report. It's the National Vehicle Motor Transportation Inspection and Safety Report, which is a lot to say, but everybody refers to it as an NVIDIS report. Those three companies track the vehicle's history, and that is a very good source to see if your odometer is consistent with what is reading on your gauge. Also, we would need to see the contract, because the contract that you sign when you buy the car has the odometer listed at the time you purchase the vehicle. So if you buy the car and it shows that it has 42,000 miles, but then we pull a Carfax and it shows that that car has 60,000 miles, most probably there's an odometer rollback issue. We would need to prove that the odometer is not consistent across the board in the three different areas: the dealership, Carfax, auto check, and your vehicle. And then finally, for advertised price violations, we would need to see an ad from the dealership. It could be on the dealer's website, it could be on some of these third-party websites, like I said, Car Gurus, Auto Trader, other third-party websites that sell vehicles will post the vehicle, post a picture of it, and a price. And the price is obtained by the dealership. So it's not like Auto Trader is arbitrarily deciding how much that vehicle should sell for. Okay, so that's a question that is very regularly asked when I do a consultation, and I always tell the clients there's a variety of ways that these claims can be resolved. First is a buyback. Some clients say, you know what, if this car's been in an accident, I don't feel safe driving it, I don't want to put my family in it, and I'm so upset that the dealer lied to me that I want to have nothing to do with this car. So we demand a rescission, which is a legal term for undoing the contract. So we tell the dealer, these are the violations, here's the documents that support our claim, and this is what we want. At this time, our client wants you to take the vehicle back, they want their money back, and they also want to get out of the loan. That is the most common resolution. The second one is a cash and keep. For instance, if the client believes that they were sold the vehicle for the above the advertised price, what will happen is, let's say they sold the client the vehicle $3,000 above the advertised price, and the client says, Pollyanna, I love this car, it drives great, I've grown to love it, it's great for my family, it gets good gas mileage, I want to keep the car, I just want the dealer to sell it to me for the amount that they advertised for. So in a situation like that, most times the dealer will offer the difference between the advertised price and the price sold. So let's say it's $3,000 different, that's what we would ask for the client. And for odometer rollback, it really depends on the client. Same thing, they could either demand a buyback, depending on how much the true mileage is, because if the true mileage is really, 30,000 miles more, that is now a 3-year older car because it has 30,000 more miles put on it. Or they may want a cash amount in their pocket, they keep the car and they keep making payments. Most clients call and they're very upset because they just found out that they've been cheated by the dealer and they want an immediate resolution. But the law that we use, which is the Consumer Legal Remedies Act, also called the CLRA, requires the consumer put the business entity, which in this case is the dealership, on notice of a violation. Once you get your documents in and we review it and we believe you have a strong enough case for us to take, then we can send you a retainer agreement and some paperwork to get even more information from you. Once we get that back, by law, again, we have to send the dealer a letter. We send the dealership a letter explaining what the violations are. We also attach the documents that you support as evidence and to show that they committed this fraud. By law, they have 30 days to respond. It's very arbitrary with respect to when they respond, if they respond, and who responds. So oftentimes I'll get a call from a dealer owner. If it's a small dealership, meaning it's not a franchise dealership, it's not Nissan or Toyota or Lexus. If it's a small independent dealership, usually the dealer owner will call and they'll say, Pollyanna, I've done nothing wrong, because they always say they've never done anything wrong. And then they say, what does your client want? I don't want to drag this out. What does your client want? And then at that time, we start negotiating. And usually with the smaller dealerships, that can happen within the first 30 days. Sometimes they don't respond at all. They'll just take our letter, put it in the trash, or they receive it, they read it, and they don't respond. Or I'll hear from their attorney. And their attorney will call and say the same thing. My client's done nothing wrong because they never do anything wrong, but they want to resolve this sooner rather than later. And then they'll ask me, what does your client want, Pollyanna? And then I'll call the client and say, look, I've heard from the dealership. They want to resolve the matter. How would you like to resolve it? And then, as we discussed earlier, it's those three options. Is it a buyback, a cash and keep, or the difference between what the client thought they were getting and what the dealer sold? One other thing that I do believe is worthy to note is sometimes the dealers are pretty adamant that they've done nothing wrong. And in fact, the dealers will produce their own set of documents, which are documents our clients have never seen or our clients never got at the time the dealer sold our client the vehicle. So they'll say, Pollyanna, we received your letter. Although your client is claiming they never knew about the accidents, here's 2 pieces of paper that show that we told your client and in fact your client signed. The interesting thing is they rarely give those papers to the client. So they'll give the client 12 or 15 other pieces of paper, but they don't give the client the most important piece of paper, which has their signature and a disclosure or a signed Carfax or a signed auto check. So sometimes that creates another obstacle that we have to overcome. And in my experience, oftentimes our clients never remember seeing that. In fact, some of our clients deny that that's even their signature. In the event we're not able to resolve at the demand letter stage, if it's a strong enough case and if the client is on board, then what happens is we have to file a lawsuit. And we won't file a lawsuit unless the client gives us authorization and tells us that they're interested in pursuing this further and they want to get this in front of a judge or a jury. And once we're in litigation, there's a whole series of other activities and steps that are involved. The majority of cases resolve even at the litigation stage without having to go in front of a judge or a jury. It really depends on the dealer's position. It depends on what the client wants. It depends on client expectations. And, we work with our clients. I always tell the clients, we're in this together. Without the client, I don't have a case. And without, the lawyer, the client doesn't have a claim. So we work together with the client, and sometimes the clients don't want to pursue litigation. They are intimidated by the process. They don't want to be involved in a lawsuit. They think it's a headache. And so we leave that choice solely up to the client if they want to pursue a lawsuit or not. A common theme that we see is once we send a demand letter out and the dealer writes back and says, Pollyanna, we did nothing wrong. In fact, here is a Carfax that your client signed. And that's always a surprise because our expectation is that whatever the client signs when they purchase the vehicle, they will get copies provided to them by the dealer. And then when we ask you for your documents, we hope that everything that you signed at the dealership, the dealer gave to you, and then you will give to us. Again, oftentimes our clients say, I never saw that. I never knew I was signing that. And the logical statement is, why would I buy a car knowing it had frame damage? Why would I buy a car knowing it has an odometer rollback? And one thing that we've seen over and over again is in the finance department's office or the finance manager's office, there's so many piles of paper and so many pieces of paper that the client has to sign when buying a car. The transactions go very fast. Most times the clients have been at the dealership for 3 to 4 hours. They're hungry, they're tired, they just want to get out of there, they have their kids with them, everybody is just annoyed and wants to be done. Well, finance companies, I believe, take advantage of those situations, and they'll put a big stack of paper in front of the clients and say, sign here, sign here, sign here, sign here. And sometimes the clients don't even see what they're signing. The finance managers will flip the papers back and have the client sign, and then they clump them up, give some of the papers to the client, not all. In response to our demand letter, they'll produce a Carfax signed by our client that our client's never seen. If you're about to go and purchase a vehicle, I recommend that you do a few things. First, look at every document separately. Make sure you're seeing the first page all the way to the last page, and look at the pages in between. Don't have the dealer have you sign some half sheets of paper. Second, demand that you get a copy of every single piece of paper that you're signing at the dealership and tell them, I've signed 8 pieces of paper, I would like 8 copies. And if the documents have multiple pages, make sure you get multiple pages. For example, Carfax can be 6 pages. Sometimes these dealers just have the client sign the last page. Well, the disclosure or the accident or the odometer information may be on the first or second page, but the clients don't see that. Third, demand a Carfax and an auto check and an Invitas report. The dealerships can print these out in seconds. Demand to get copies of all of them and review them before finalizing your purchase.